Well, good morning. I hope everyone can hear me okay, court reporter. So I first want to thank everyone for bearing with us for this long trial. And I know it's been a long 2 weeks, over 2 weeks for this trial. And I'm sure you're all ready to get back to normalcy in your lives. But thank you for giving a part of your time to us and your dedication, your concentration for all sides, for the state and for the defendant. Defendant, armed with multiple weapons, with a pile of ammunition, prepared himself for the events that played out on May 27th of 2020. A book that was found in the defendant's living room was evidence of the defendant's state of mind and his intentions that day. If you recall, that book that was in his living room, opened up, was on the page of homicide. It had definitions on that page: justifiable homicide, excusable homicide. Law enforcement officers that went to the apartment number 303 that day had no idea what the defendant's intentions and state of mind were. When they went there to execute a judge's order to evict him and remove him from the apartment that he was evicted from. The only person that was prepared on May 27th of 2020 was the defendant. Defendant placed a 2x4 on his front door, ran back to the bedroom, locked the door, grabbed a loaded AK-74 and positioned himself right in front of that bedroom door, waiting for law enforcement to open that door so he could pull the trigger. Defendant knew it was law enforcement on the other side of that door. Defendant knew they were there to evict him and remove him. Defendant knew if he didn't open that door and come out and leave this property that he was evicted from, he was going to go to jail. Defendant told the deputies when he was on the other side of that bedroom door that he wasn't going anywhere. And his actions showed his follow-through that he wasn't going anywhere. Right before Deputy Nord reached that bedroom door, deputies talked to the defendant for a while. As soon as that door was breached, if you recall Detective Matson's testimony, just 0.36 seconds after that door was kicked, defendant's bullet traveled right by Deputy Nord's head. Deputy Nord was just standing there with the eviction papers in one hand, his hand to his side with his other hand. Another one of defendant's bullets then traveled out his bedroom and struck his mom on the right side of her head, killing her. Deputy Mclean was only about a foot away from Miss Moore when she was struck. As soon as this happened, Deputy Nord immediately retreated down the hallway. He testified that he got about 3 to 4 feet down that hallway when he returned fire. Deputy Mclean retreated to the bathroom. He testified that he never even fired a round. Evidence in this case corroborates that neither deputies fired their weapon when they were standing at that bedroom door. There was not one piece of evidence that showed any shell casings from the officer's 9mm outside that bedroom door. There was one shell casing from the officer's weapon in the bathroom. But as you recall, after Deputy Mclean retreated to the bathroom, he saw the defendant's gun, the barrel of his rifle, stick out the door. That's when he fired his shot. The only other 9mm unspent, just a bullet that was, I think it was a 9mm, was in the defendant's bedroom, was not from the officer's weapon. As you recall, Agent Quam testified that this was intact bullet. No evidence to support the defendant's claim that when the officers breached that door, they fired their weapon and shot him in the arm. Not one piece of evidence supports that. Now, when Deputy Mclean was in the bathroom, this is when they radio for help. Dispatch goes out, shots fired. The first two officers that arrive on scene and enter that apartment are Corporal Toro and Officer Cody Holte. When they get in the apartment for the next 14 minutes, the officers did everything they could to get the defendant to come out of that bedroom without anyone getting hurt. But the defendant had already made up his mind how this day was going to end. And it wasn't going to end peacefully. Corporal Toro testified that he saw the defendant quickly run out of his bedroom, firing as he ran behind that kitchen divider wall. And for the next 19 seconds, rapidly fired, aiming at these officers. I want to now go through some of the charges in this case and some of the elements for each of these charges. The first one that you'll look at in your verdict forms is the murder of Officer Cody Holte. Now, there are three elements to murder. The first one is willfully cause the death of Officer Holte. The second one is under circumstances manifesting extreme indifference to the value of human life. And the third one, the defendant did not act in self-defense. Now, when I go through these elements, I'm first going to go through the first two, and then later on we'll talk about defendant's claim of self-defense. Willfully. I put the definition of willfully up here because this is important. Willfully is either intentionally kill someone, it's an intentional act, or it's an act that you know what you're doing, it's a knowing act, or it's a reckless act. Any one of these will prove willfully caused. And in this case, the state would argue that the defendant did intentionally cause the death of Officer Holte. This was not an accident. At a minimum, defendant recklessly, his actions were reckless, causing the death of Officer Holte. Let's go through some of the facts with regard to count one. This case is unusual in the fact that we have the murder on body cam. There's no doubt who caused the death of Officer Holte. We have Mclean's body cam showing the defendant firing in Officer Holte's direction. This body cam video and the trajectory evidence shows that the defendant fired directly at Officer Holte. You see the flash from the bullet hitting the vest of Officer Holte. The photographs that you saw in this case shows Officer Holte's camera has a bullet defect in it. You see Officer Holte fall to the ground. Defendant takes the stand. He admits he was aiming at Officer Holte. He saw him. He testified that he was an easy target. Defendant fired at an aggressive rate at Officer Holte. You saw all of those bullet defects in that kitchen table over there. Approximately 14 bullet defects. Intentional. There was nobody else responsible for Officer Holte's death in this case. We also have the bullet fragments in this case that also support it was defendant who killed Officer Holte. Dr. Capone testified that he retrieved bullet fragments from Officer Holte in 3 different locations. These bullet fragments were then sent to Mr. Moritz in South Dakota for ballistics examination. Mr. Moritz told you that these bullet fragments were consistent with 5.45 by 39 millimeter bullets, ammunition. The defendant was the only person using this type of ammunition. Mr. Moritz could testify that conclusively it was not a 9 millimeter bullet fragment that the officers were using that day. The second element is the state has to show that there was an extreme indifference to the value of human life. Firing multiple rounds towards Officer Holte with an AK-74 assault rifle in a small apartment proved that the defendant acted under circumstances manifesting his extreme indifference to the value of human life. When you point an assault rifle and fire multiple times aiming for that individual, there could be nothing less than them having an extreme indifference to the value of human life. That's the ultimate extreme indifference to the value of human life. During this rapid fire, aggressive fire, the wooden table in front of Officer Holte is struck numerous times, causing the defendant's bullet to tumble. And this is what resulted in those devastating injuries on Officer Holte. The amount of bullet holes in this table, as well as the amount of bullet holes in this window right behind Officer Holte, shows his extreme indifference to the value of human life. Agent Matson had testified that Officer Holte never even had a chance to fire his weapon. Other testimony showed there was no bullets missing from Officer Holte's weapon. Defendant is guilty of count 1, the murder of Officer Cody Holte. Let's take a look at count 2. Count 2 is the murder of Lola Moore. The first element, again, same elements. Defendant willfully caused the death of Lola Moore under circumstances manifesting his extreme indifference to the value of human life. And the defendant did not act in self-defense. Deputy Mclean's body cam video shows that it was the defendant who caused the death of Lola Moore. Agent Matson was able to slow down that video and show right at the time when Lola Moore was struck on the right side of her head. You could see that at the time that Lola Moore was struck, neither Deputy Nord or Deputy Mclean was in any position or had their weapon pointed in the direction of Miss Moore. The trajectory analysis supports that it was the defendant who shot his weapon out his bedroom wall, went through the wall, through her door, and struck her in the head, killing her. And again, Dr. Kaponen retrieved bullet fragments out of Miss Moore's skull. He not only retrieved bullet fragments, but he was able to retrieve a partial bullet. And he was able to determine that this bullet was a 5.45 by 39 millimeter bullet. Again, consistent with defendant's ammunition and inconsistent with the deputy's ammunition. Defendant fired his weapon blindly, as he testified, at least 20 times through the bedroom wall, not knowing who was on the other side of that wall, who was going to be in the path of that bullet. At a minimum, defendant's actions were reckless. If you find that the defendant recklessly caused the death of Lola Moore, under circumstances manifesting his extreme indifference to the value of human life, then you must find him guilty. The next slide that I'm showing you is the trajectory analysis that Agent Kraft had put together. Agent Quam testified that the bullet that struck Miss Moore originated from the defendant's bedroom. This trajectory did show that it went through his wall and struck her. When you are determining whether or not the defendant is guilty of murder of Lola Moore, keep in mind that the state does not have to prove that he intended to kill his mom. That's why we talked about the definition of willfully. Either intentionally killing someone, knowingly killing someone, or recklessly killing someone. Willful conduct includes reckless conduct. And at a minimum, defendant's actions on May 27th of 2020 were reckless. Again, manifesting his extreme indifference to the value of human life by firing an AK-74 assault rifle blindly at his bedroom, knowing that there were people out there, knowing that his mom was home, knowing that his mom's bedroom was right next to his bedroom. The This is an extreme indifference to the value of human life when you do that. I want to go through some of the extreme indifference factors, and these are just a few of them. I'm sure singly and collectively, you can probably come up with a lot more than I came up in this slide. Extreme indifference. You're showing extreme indifference by the choice of weapon that you choose. You show an extreme indifference by the choice of ammunition you choose. And there was a lot of testimony on this weapon and this ammunition. This was a high velocity rifle, full metal jacket bullets that cause extensive damage. You saw just how powerful these bullets were, not only from the autopsy photos and the damage that injuries that they caused, but these bullets going all the way through multiple doors into multiple apartments, across a courtyard, and into another apartment building, and into the bedroom of that apartment building. This is powerful. That's an extreme indifference. He didn't grab a pistol. Rapidly firing outside his bedroom, knowing his mom was in the apartment, and firing multiple rounds without regard to human life. Even by defendant's own admission, firing at least 20 rounds blindly. This is an extreme indifference. And I ask that you find the defendant guilty of count 2 for causing the death of Lola Moore under circumstances manifesting his extreme indifference to the value of human life. The third charge that you will consider is the attempted murder of Corporal Pat Toro. The first two elements are just the date and the defendant. May 27th, 2020, the defendant intentionally engaged in conduct. State has to show the defendant engaged in some conduct that showed a substantial step towards committing the crime of murder. And in this case, Corporal Pat Toro. And again, we'll talk about this a little later on. He did not act in self-defense. Criminal attempt, it's kind of just what you think it is. It's some conduct on the part of the defendant that shows what he's trying to do. In this case, attempting to commit the crime of murder. The evidence in this case showed, beyond a reasonable doubt, that the defendant was attempting to kill Pat Toro. Defendant from multiple bullets, aiming at Corporal Toro. There could be no other intent when you aim and fire an assault rifle at someone. You're attempting to kill them. Corporal Toro testified that the defendant stuck his head out of the bedroom, and that's when he saw him quickly run over to that kitchen divider wall as he ran out, firing his weapon. He said they made eye contact. Corporal Toro saw a muzzle flash, saw the defendant firing his weapon. Corporal Toro also testified that in hindsight, when he recalled the defendant peeking his head out a few times before he ran out, he now believes that was when he was scoping out where all the officers were located, try to gauge where they were at before he ran out. Let's look at some of the substantial steps that the defendant did. This trajectory photo shows just how many substantial steps the defendant took. Corporal Toro was standing right behind that pool table, right in front of a lot of these bullet holes in the wall. Defendant shot towards Corporal Toro for at least 19 seconds. Defendant's testimony that he was only trying to shoot at their legs, whatever weight you want to give that, he was still aiming at these officers. He was aiming pretty high. Look at how high a lot of these bullet defects are. He was shooting to kill. This is the pool table right there where Corporal Toro, remember when in the body cam video he was leaning over that pool table? Look at all those bullet defects right behind him. A substantial step. The fourth count that you'll consider is the attempted murder of Deputy Kelly Mclean. The elements are the same. May 27th of 2020, intentionally engaging in conduct constituting a substantial step towards the commission of the crime of murder. And in this case, Deputy Kelly Mclean. And he did not act in self-defense. Let's look at some of the evidence to support this charge. First, I want to talk about the substantial steps that the defendant took at the bedroom door. When Deputy Mclean and Deputy Nord were standing on each side of the defendant's bedroom door, talking to him, he could hear their voices. He knew the approximate location of where each one of these officers were. Exhibit 194, see that bullet defect right at the top left-hand side of that photo. That was the bullet defect that caused the fatal injury of Miss Moore. That was only about a foot away from where Deputy Mclean was standing and talking to the defendant through that door. Firing your AK-74 out your bedroom toward Deputy Mclean's voice is a substantial step. Look how high that bullet is, too. Right at their head. You can also see all those other bullet defects. See inside the closet, all those substantial steps. You also got to see Deputy Mclean's body cam video. And if you recall, right when the gunfire broke out, Deputy Mclean drops to the ground and starts crawling back behind that pool table. Look at all the bullet defects down there where he was at crawling. Agent Kraft testified that Deputy Mclean was in the area of the window of the apartment in that it appeared the shooter was changing aim as he fired at officers as they were kneeling and standing. All these facts support and are evidence of defendant taking a substantial step towards a crime of murder regarding Deputy Mclean, and that his actions did manifest his extreme indifference to the value of human life. And again, ask you to find the defendant guilty of attempted murder of Deputy Mclean. I want to show you Exhibit 9. This is the freeze frame video that, or the video of Deputy Mclean's body cam. And this is right before Deputy Nord kicks in that bedroom door. And I show this photo because it gives you an idea just exactly how close Deputy Mclean was to dying that day. Intentionally aiming and firing at Deputy Mclean showed his extreme indifference to the value of human life. This is the freeze frame, Exhibit 154, when it is believed that Lola Moore was struck. You can see Deputy Mclean's arm there right at the bottom. Not only showing, again, it was not anybody but the dude who shot his mom, but again showing just how close he was, how close that substantial step was of the defendants that day. The next count, count 5, is the attempted murder of Deputy Ron Nord. Same element, May 27th of 2020, the defendant intentionally engaged in conduct, taking a substantial step towards killing Deputy Nord, and he did not act in self-defense. Defendant intentionally aimed and fired at Deputy Nord while he was at the bedroom door. The first substantial step. Let's take a look at that freeze frame, exhibit number 154. Deputy Matson is able to freeze frame it right when you see the streak of the bullet. You see too, when you first see the streak, it's not quite to Deputy Nord's head, it's about halfway there, and then the second freeze frame is when it continues on past his head. This substantial step, again, came very, very close, not just an attempted murder, but in fact the murder of Deputy Nord. Pointing and firing your AK-74 at the head of someone coming in your bedroom shows an extreme indifference to the value of human life. Defendant loaded his assault rifle, positioned himself in front of the door, and aimed out the door, knowing that the deputies were out there. Pulled the trigger. All substantial steps, all intentional acts. If Deputy Nord had been just a little bit over to the right, this would have been murder. Defendant's actions were a substantial step that fell short of killing Deputy Nord, showing his extreme indifference to the value of human life. The next substantial step that I want to talk about with Deputy Nord. Deputy Nord's now moved into the kitchen area, and he's hiding, taking cover behind that kitchen counter. Defendant fires multiple rounds right in the direction of Deputy Nord. The bullet trajectory shows that the shooter was right behind that kitchen divider wall when that shot was fired, striking that corner of that kitchen counter and striking Deputy Nord in his leg as he was crouched down. Defendant again came very close to killing Deputy Nord when he was in the kitchen. Defendant was clearly aiming at Deputy Nord. Defendant aiming at Deputy Nord and pulling the trigger of his AK-74 was a substantial step towards intentionally or knowingly killing him. Quam had testified that based upon the positioning of the other officers, the only person that could have caused this injury was the defendant. Agent Kraft testified that the bullet originated from the defendant, and he would assume, based upon his analysis and the shooting reconstruction, that aim was involved. Deputy Nord also made injuries to his abdomen from the defendant's gunfire. Again, substantial steps showing the defendant is guilty of the attempted murder of Ron Nord. Sixth count is criminal mischief. There are two elements to criminal mischief. On May 27, willfully damaging someone else's property is the first element. And the second element is we have to show that he intentionally caused over $10,000 worth of damage. The state has shown through the testimony and the exhibits that the defendant intentionally fired his weapon at least 48 times in that apartment. We know this because there was 48 shell casings of the defendants found in the apartment. So that's a minimum number he fired. Andrew Horgy testified to the damages to his apartment. He testified that he had them repaired. You have an exhibit that was entered that showed over $40,000 worth of damage to this apartment. You heard the officers testify about the damage when they walked in. It looked like a war zone. Appliances shot out, walls shot out, doors shot out, water heaters, flooding, blood everywhere. The damage was more than $10,000. And the state would request that you find him guilty of criminal mischief as well. Terrorizing. There's two elements to terrorizing. The first element is kind of like an alternative. On May 27th, the defendant either intended to cause terror or he recklessly caused fear. And he threatened to commit any crime of violence or act dangerous to human life. You can terrorize someone with actions. It doesn't have to be words. You can point a loaded gun at someone, and that's terrorizing. You don't have to say, I'm going to kill you. Having a gun at your face loaded is terrorizing. The state would submit that we've proven both of these, even though we only have to show one of them. Defendant intend on instilling fear and terror in these officers. There was no other reason. and at a minimum, pointing a rifle, his assault rifle, directly at them, pulling the trigger 48 times, was in reckless disregard of causing such fear. Deputy Mclean had testified that he could see the barrel of the defendant's gun when he was inside the bedroom. He testified that he didn't think he was going to get out of there alive. He thought he was going to die. This evidence in of itself supports a guilty conviction for terrorizing. Even though the state only charged this out as one count, there were more people that were terrorized on that day. Deputy Ron Nord. Immediate gunshots rang out when the bedroom door was breached. It was dark, but he could see that muzzle flash. He was trying to get out of the line of fire, and he testified that after the first volley of gunfire, he didn't know how it was going to turn out. He didn't know how it was going to turn out. Inferring he didn't know if he was going to make it out of there alive either. Corporal Pat Toro, he testified the defendant had a long gun. And he testified that the vest that each one of those officers were wearing would not sustain a rifle bullet. He knew when he was there, if he got hit, that ballistics vest he had on was not going to protect him. He saw the muzzle flash when the defendant was firing directly at him and aiming at him. When we think about terrorizing, the second volley of gunfire was 19 seconds. And you'd think that isn't a lot of time. But it is a lot of time. It's 19 seconds of someone firing an assault rifle right at you. There's a green box on this particular slide right here. And when I start moving this green box, it'll start going down. When it is completely out of the picture, that's when 19 seconds is gone. This is how long those deputies were under fire. Count 8 is the reckless endangerment charge. There are 3 elements to reckless endangerment. Defendant has to create a substantial risk of serious bodily injury to another. Circumstances that manifest as extreme indifference to the value of human life, and his actions have to be reckless. Several witnesses testified to this reckless endangerment charge. And let's go through some of those witnesses. You heard from Officer Rebel. Officer Rebel had testified that when he was outside that Bearcat, right outside that window where all those bullets were coming through, that he thought he was being shot at. He was being hit in the face with shrapnel, and he also found some glass in his hair when he got home. Defendant firing his weapon with bullets that went all the way out his window was nothing short of reckless acts. Reckless acts that did create a substantial risk of bodily injury to someone else. Any bullet traveling out of that window and striking someone would definitely create substantial risk of bodily injury. Officer Younger and Officer Broughton also testified to this. What about Femby Miriam? She was the resident of apartment number 304. Remember, she testified that she had heard an explosion. She was scared. They also found a bullet hole in her bathroom and a bullet fragment. Apartment number 304 is right next to defendant's 303. When defendant shot out of his apartment, through the wall, going into another apartment, was reckless behavior that did create a risk of injury to somebody else. How about Miss Vanskoy? She lived right below the defendant. She was scared, in shock, and officers, when they searched her house, they also found bullet fragments from the defendant's ammunition in her apartment. There was one lodged in her air conditioner in her living room. That bullet going into apartment number 203, defendant's bullet, again, that standing alone would create a substantial risk of bodily injury to another person and show his reckless acts. Martin Smith testified as well. Martin Smith was the tenant of the apartment just straight across from the defendant. Martin Smith's front door had bullets going through it during that first volley of gunfire. If you open the defendant's bedroom door and look straight down that hallway, it'll go out that front door right into Mr. Smith's front door. We brought in Martin Smith's front door as an exhibit. You can see all those bullet defects that went through his front door. Defendant's bullets that had Mr. Smith been standing there, he would not have been here either. Substantial risk of causing bodily injury to Mr. Smith. And defendant's actions, again, were reckless. You recall Mr. Smith had testified that just before he heard that gunfire, that first volley of gunfire, he was standing in front of his door. He looked out the peephole. He opened the door. He was that close. Agent Quam also testified to the bullet defect in Martin Smith's apartment. It was above the TV, and he had testified that had somebody been standing in the bedroom in front of that TV, they would have been hit by that bullet, defendant's bullet. Agent Kraft had also testified about the bullet defects right outside the defendant's front door of his apartment. Remember in the body cam evidence where the apartment manager was standing, Andrew Horgy? Andrew Horgy was standing right off to the side where all those bullet defects were. If he had been there just a few minutes, at a different time later, he hadn't moved, he would have been struck. Agent Kraft also testified to the apartment across the courtyard where the bullet exited through that window in defendant's apartment, went into the apartment building across the courtyard, penetrated that building, and went into that tenant's living room. They found defects in that apartment as well. The last count for you to consider is the possession of marijuana with intent to deliver. And there are three elements to this offense. May 27th, the defendant willfully possessed marijuana with intent to deliver it. The state submitted State's exhibit numbers 127 and 131. Agent Carter testified to the evidence. Agent Carter had testified that when they searched the defendant's safe, they found all of these bags of marijuana. An amount, he testified, that along with the scales, baggies, all the money that was with it, indicative of someone who sells marijuana. But we didn't have just all this marijuana, cash, scales. State also entered text messages from the defendant's phone. And if you look at those text messages, there was dealing, selling marijuana as recent as May of 2020. And this happened in May of 2020. Further corroborating that the defendant was selling marijuana. I want to speak a little bit about self-defense now. And what is not self-defense? Self-defense is not justified if that person wants to use self-defense to resist arrest, to resist execution of process, which is what the deputies were doing in this case, or any other performance of duty by a public servant, unless those officers are using excessive force. There was no evidence in this case that the officers used excessive force. Defendant set this in motion. It was defendant's actions. It was the officers who needed to defend themselves from the defendant. The evidence in this case showed beyond a reasonable doubt that the deputies were engaged in their official duties when they went to apartment number 303 to execute a judge's order, enter, and remove the defendant from this apartment that he had been evicted from. The state offered a copy of that judge's order. That judge's order, I believe, was signed on May 24th. Officers still waited 3 more days before they even went over there to remove him on May 27th. Defendant was not justified in using self-defense to resist being evicted from that apartment. Defendant's claim that officers fired at him while at the bedroom door is contradicted by all the evidence. There's not any evidence to support the defendant's claim that either one of these officers kicked that door in and fired at him, shot him in the arm. Not one piece of evidence. Defendant's claim that as soon as he walked out of the bedroom, when he claimed he was going to surrender, and he said, "I didn't even hardly get past the threshold of my bedroom before they started firing. I didn't even make it to the kitchen divider wall," again, is contradicted by all the evidence in this case. Defendant's story that he only fired after he saw his mom laying on the ground and that scared and traumatized him is contradicted by all the evidence. Body cam evidence shows defendant fired his weapon before his mom was struck. One of the jury instructions that you'll be given when you go back to deliberate this case is the weight and credibility instruction. This instruction allows you to put whatever weight you want to whatever piece of evidence, whatever testimony. That's up to you. You can believe who you want. You cannot believe who you want. And it also tells you when you're deciding this, one of the factors you should decide or you should take into consideration is that person's possible interest in the outcome of the trial. There's not one person in here, not one person that took that stand that has a greater interest in the outcome of this trial than the defendant. And you can consider that when you put whatever weight that you want to give to the defendant's testimony. You also should consider whether or not that person's testimony is reasonable or unreasonable. And I submit to you that defendant's testimony on the stand was not only unreasonable, but it contradicted all the physical evidence, all the body cam evidence, all the trajectory evidence, everybody else's testimony. The other jury instruction is proof of fact by a single witness. And I point this one out to you because this jury instruction specifically says that a fact can be proved by one witness, but before finding it solely on the testimony of one witness, you should carefully consider all of that witness testimony upon which proof of the fact depends. Defendant in this case was not justified in using deadly force. Defendant used deadly force to resist an eviction or resist arrest when the officer said he would go to jail. You're not justified in using self-defense against a law enforcement officer to prevent being evicted from the apartment, to prevent being arrested. Defendant's claim about coming out of that bedroom, officers firing immediately upon him, doesn't even match with the audio evidence in this case. When you listen to the officers right before that second volley starts, you can hear how surprised, how caught off guard they are. You can see on the body cam how they try to jump out of the way. They are taken by surprise.
You can work out everything else afterwards.
All right. Going 2627 over here, definitely the building. We believe it is the
You can work out everything else afterward.
Remember in jury selection when Ms. Neufeld showed a picture of Mount Rushmore? Beyond a reasonable doubt does not mean beyond all doubt. you can still put the pieces together and have a firm and abiding conviction that the defendant is guilty. If you can still tell that this is Mount Rushmore, even though one of the faces is missing, you should find the defendant guilty. One last thing that I want to talk about is the verdict forms. Count 1 and count 2 are probably the longest. So I just wanted to explain them a little bit. State charges out as murder, extreme indifference. That's the first page on count 1. And when you go back to the jury deliberation room, I ask that you find beyond a reasonable doubt that the defendant willfully caused the death of both Officer Holte and Lola Moore, that you check the guilty box right on this first page. Once you check that guilty box, all this doesn't matter. Everything behind this first page are all the lesser includeds. Lesser includeds, if you find that the defendant had a reasonable excuse for doing it, a justification for doing it. If you find, first, all of you have to find unanimously not guilty of murder. You all have to say not guilty of murder before you can even flip this page. I submit to you that the state has proved that the defendant willfully caused the death of Lola Moore, Officer Holte, the attempted murders of all 3 of those deputies, reckless endangerment, criminal mischief, and possession of marijuana with intent to deliver. And I ask, when you go back to that jury room and you pick a 4-person, that you mark guilty on these. Tell the defendant that you are not finding that he had a reasonable excuse for the fatal actions that he took on May 27th. Thank you.
Thank you, Ms. Matson. Mr. Mottinger, you prepared to do your closing argument?
Ma'am.
You do so.
Morning. We've been at this for a while, and I suspect that you're going to be at it for a while as well. One of the things that's so difficult putting together a closing argument is that although we can anticipate the state is going to argue, points they're going to make and the facts that they're going to ask you to consider, we really don't know what sequence it's going to be given to you in. And we are kind of put in a position that we have to be able to react or explain some of the points raised in the state's argument. Before getting into what I thought I was going to talk to you about, I want to, if I could, take a couple minutes and just go over some random thoughts that I wrote down during the state's presentation. Before I get there, I would like you to know that one of the first things I sometimes do when I pick up a case like this is figure out who the prosecutor is going to be, perhaps is going to be on the prosecution team. And sometimes I make some calls to other defense attorneys to find out how that particular prosecutor approaches cases like this. Sometimes I rely on my past experience with the prosecutors involved. I have worked with both Ms. Madison and Ms. Neufeld before. As I said, I made a couple calls. I expected them to be good. They were. That was a very compelling closing argument. But if you've already decided what you're going to do based on that argument, we might as well pack up all our things and go home right now, because the rest of this is going to be a monumental waste of everybody's time. Looking at you, I get the sense that you don't want to go home just yet. You realize that there is more to this, simply a recitation of facts from the state's perspective. If you remember, during jury selection, we talked a lot about perspective, how two people can view the same incident and honestly have a different perspective on what they saw. In our opening statement, we talked about perspective and sequence, why they might be important. Before I get into that, I just want to go over some random notes that I made during state's closing argument. First of all, in regard to body camera footage and body camera audio, what do they really show us? I want you to, when you get into that jury room, take a look at that body camera footage. Listen to the audio that goes with it. What do the stills pulled from the body camera footage really show us? A lot of that stuff is open to interpretation. A lot of it can be looked at from several different directions. There was some talk about an aggressive rate of fire. A lot of shots fired, I think, and again, rely on your common recollection of this, not on mine. We attorneys sometimes get so wrapped up in all this that we tell you our own viewpoint, our own idea of what did or didn't happen, but rely on your own recollection. It seemed to me an argument can be made that everybody fired an aggressive rate here. 78 total shots, 2 separate volleys. Just heard the audio. It wasn't just one person firing at an aggressive rate. Remember during opening statements when we talked about the idea that to be believable, you have to be believed, you have to tell the truth, or at least acknowledge the truth even when it hurts? Well, whether we want to admit it or not, whether Mr. Pendleton is at a point in his life where he can admit it or not, and he's got his own perspective on what happened, and he's entitled to that. There's no dispute as to who killed Officer Holte. He admitted that he fired at it. Ballistics are clear. Copper-jacketed bullet. We're not disputing that. It's also apparent that he was responsible for the death of his mother. Again, we've got a copper-jacketed bullet. The officers involved had copper-jacketed bullets. Can't really dispute those facts. again, I think in order for you to appropriately analyze this case, you have to consider again perspective and sequence. Getting back to some notes I made during the state's opening, you're going to see reckless conduct in the instructions several times. There's going to be a definition. It's going to be considered in the murder instruction, also in the manslaughter instruction. However, only time reckless conduct can be considered in that murder instruction is if you find he acted in extreme difference to the value of human life. That's kind of a speculative concept. It's going to be your job to make that determination. What does the choice of weapons have to do with this other than it was a choice of weapon? Think about that. Is an assault rifle inherently any worse than any other weapon? In regard to the death of Lola Moore, did he fire into his mother's bedroom? Submit to you that the evidence does not necessarily indicate that. Exhibit 194 you took a look at. That's the purported Moore bullet trajectory. Does that prove, or is it inconclusive? Again, we're not suggesting that she was not killed as a result of a bullet fired from his weapon. I think you need to take a look at that exhibit and maybe it plays into all of this. How does intent go into the analysis of attempt? Take a look at the instructions. A lot of talk about things that could have happened, didn't. Why is that important? You're going to have to decide. State referenced the fact that the officers were under fire for some 19 seconds. Wasn't the defendant under fire during that time period as well? Clearly, there was no intent to hurt somebody in another building. Reckless endangerment, what's that mean? Finally, we talk about the safe. They talked about the safe. We'll talk more about that later. What's the significance of the cash? What's the significance of the cash in the safe? I don't know. Where else would somebody keep cash? Going to have to decide that count. Those are just some random thoughts I wrote down during the state's argument. Already talked a little bit about perspective and sequence. I suggested to you earlier in the trial that those would be important concepts for you to consider during your final deliberations. Today, I'm asking you to keep that in mind. Trials like this are hard. Really hard, really draining on everybody involved. Prosecution, defendant, families, and for juries. This isn't easy stuff. Jury service is never easy. Trials like this are probably more difficult than others. But they are what they are. Some say time is like a river. It cannot go back and touch the same water twice, because the flow that has passed never pass again. It's gone. Can't go back and undo anything that happened on the 27th of May, as much as we would like to. But I would submit to you that one thing is abundantly clear. Nobody involved in this thing when they got up in the morning of the 27th had any idea that it was going to end this way. Nobody. You talked about how if we're going to be believed, we must be believable. Be believable, we must at least acknowledge the truth, even when it hurts our case. What is the truth? Truth is really nothing more than perspective, our own perspective. You can look at an end result. It's how we got to that end result that's really important. You know, at times like this, wish I was a better lawyer. Been doing this for a long time. Had a lot of juries just like you, a lot of different kind of cases. Every time we get to this point in the trial, I get scared. Get that funny feeling in the pit of my stomach. I'm talking. I'm always afraid that I should have done something different. Should have done something better. Afraid that I'm going to disappoint my client. I'm afraid that I'm going to disappoint you. I think after doing this for 40 years, I'd get over it, but I don't. You know what? Maybe when I don't feel that way anymore, it's going to be time to quit. Been doing this for a long time. Not ready to quit now. Not going to quit on my client, because I think there are some facts and circumstances in regard to this case that you really need to think about. Really do. The state doesn't get to pick their cases. Represent the people of this county. Got a job to do. As I indicated to you a little earlier, they're pretty good at it. I've got a job to do too. Hey, it's my honor and my duty and my privilege to stand up here as an advocate for my client, Salamah Pendleton. In my mind, for what it's worth, there's no higher calling for any lawyer than to do that job. Because you, as a jury, are the last thing stands between folks at that table, Salamah Pendleton. Last thing that stands between them. Some years ago, a friend of mine asked me why I did what I do, why I represent criminal defendants. I said, why are you always on the wrong side? Thought about it for a minute, and I looked at him and said, I'm not on the wrong side, I'm on the right side. On his side. By being on his side, by definition, I'm on your side as well. Why? Why, you might ask? Because he is one of us. He is one of us. He's one of you. He's a part of this community. Because of that, because of the protections given to him by the Constitution of the United States and State of North Dakota, he's entitled same constitutional protections that all of you are. In this case, you are the mutual deciders of fact. What is true, what is not. More importantly, what can be proven and what cannot. Burden of proof is theirs, not ours. Come into all of this after promising all of us that would weigh any preconceived notions that you might have in terms of what did or didn't happen. We hold you to that promise. Hold yourself to that promise. Get into the jury room, you look at the person on your right, look at the person on your left, person behind you, person in front of you. Make sure you hold them to that promise as well, because that's the only way that this thing works. It's the only way that this thing works. Got to keep an open mind. Got to keep an open mind. A little bit, I'm going to talk about the evidence that you're being asked to consider. You remember in our opening statement, we talked about my old antique dining room table. Important decisions that were made around that table. Shortly, your time to sit around that same kind of table is going to come. I want you to think back to the discussions that took place around that table. Making those important decisions that we talked about, the different family members have different perspectives on every single decision that was made. Did they not see things from their own individual point of view? Was the final decision they made to sell a crop or part of a crop, to sell some livestock, or to buy a new tractor made in a vacuum? One person probably didn't get to make that decision. Decisions like that were made by the family. Decisions in this case are going to be made by you. Made those decisions, things they considered might be dependent on one thing, might be dependent on something else, might ultimately be decided by sequence of events as they believe them to be, or as they believe them to come. Perspective and sequence. Perspective and sequence is what this is about. 9 separate charges you're being asked to consider. I would submit to you that there's nothing in instructions requires you to consider count 1, I will refer to as the Officer Holte charge, and count 2, that I will refer to as the Lola Moore charge, that particular order. I think it's important that you reverse that order, because that will put the case in its proper sequence. Because what did or didn't happen to Ms. Moore, ultimately, our perspective led to what happened to Officer Holte. So let's start with the charge. The officers, deputies, Corporal Nord and Sergeant Mclean were there to serve legal process. In the exhibits you're going to take into the room, there's a copy of that writ of restitution. Bring them to take possession of the premises. best of my recollection, none of the legal documents that led up to that writ of restitution are in the exhibits that you're going to get a chance to look at. You might ask me, why is that important? What did Mr. Pendleton tell you? He had no knowledge he was going to be evicted. Said they had eviction papers, took him by surprise. I recall him talking about the fact that he was worried about being evicted, middle of a COVID crisis. He had nowhere to go. He talked to us about how mother came up here a couple of years ago, wanted a new start. It's kind of her caretaker, took care of her, that she was on some medication. Is it reasonable to believe that somebody in charge of and responsible for the care of somebody else had nowhere else to go, being evicted? Don't you think that that would bother them? Don't you think that that would cause them some stress? Submit to you that it would. In each of the 2 murder charges, they put a defense instruction. Extreme emotional disturbance. Would submit to you being booted out of your apartment, a place to go in the middle of a pandemic, could cause somebody to be a lot of emotional stress. State's probably going to argue to you in their rebuttal at it during their closing. You can't get that far. You have to find him guilty of his mother because of the circumstances manifesting an extreme indifference to the value of human life, part of that instruction. Let's talk about that for a minute if we could. He wants to admit it or not, he fired that shot. Sorry. There's no other way that it can be explained. He didn't intentionally shoot at his mother. Didn't shoot into her room. He didn't know where she was. Simply because she was in the same apartment, does that necessarily mean that they've shown that he acted under an extreme indifference to the value of human life in regard to the shot that killed his mother? I would submit to you that it doesn't. It wasn't his intent. And he's under an awful lot of stress, taken by surprise by this whole sequence of events. You can skip the extreme emotional disturbance instruction if you want to, and you can go right down to manslaughter. I think at this point you need to be made aware of the fact you heard the instructions. One of the key words in murder instruction is reckless. The elements. Get down to manslaughter. It's also a key element. And before you can convict him in a murder charge, you have to find, with regard to the death of his mother, he acted in extreme indifference to the value of her life. What's extreme indifference? Extreme indifference might mean firing into a crowded theater, firing into a crowd of people. Again, at that point, the person who did that, perceive the possibility. You don't know somebody's there when you don't know where they're at. You don't fire into their room. It's reckless conduct. Reckless conduct. Best. Got a manslaughter case against Mr. Pendleton in regard to Lola Moore. Wasn't his intent. I'm going to tell you intent doesn't matter, and it probably doesn't. But her death was certainly not anticipated by him. Let's talk a little bit about Officer Holte. Before I forget, there's a specific instruction, sympathy, fair treatment under the law. Sympathy can play no part in your deliberations. I think everybody in this room is sorry that a lot of things happened that day. Get into that jury room, sympathy can play no part in your deliberations. But taking a look at the Officer Holte charge. At the time Officer Holte came to the apartment, any extreme emotional disturbance Mr. Pendleton was suffering had been exacerbated by the fact that he knew his mother was down. She was dying. How do we know that? Listen to the pleading in those audios. Somebody help my mother. Get her some help. Clearly he is distraught. At that point, does he perceive that he responsible for her death? No. But he knew she was down. So state of mind is altered. He's already under stress because he had nowhere to go. He was afraid. Now his mother's dead. That is an extreme emotional disturbance. I don't know what is. Again, what I don't know doesn't matter. You're the ones that are going to have to decide that. And it's an included offense. It's not like if you find him guilty of that, all this is going to go away. Let's talk about a couple other things in regard to the Officer Holte charge. Instructions are clear. You can't use self-defense as an argument if you're resisting the lawful service of process. You can't really use self-defense if somebody, law enforcement's trying to arrest you. You can use self-defense. The force law enforcement uses in that particular situation to accomplish what they believe they need to accomplish is excessive. All of this took place in a relatively short period of time. Get into that jury room, you need to look at all those videos. They're all time-stamped. If you saw that when they played or not, take a look in the upper corner, they're time-stamped. I'm going to be dealing with two separate altercations here, the initial and the second sequence of gunshots. So he comes out of that room after begging somebody to help his mother, and they said, no, we're not going to do that. You've got to come out. So he comes out, and from his perspective, he gets fired on. From their perspective, he fired first. Witnesses are presumed to tell the truth. So in order to put this thing together, you're going to have to look at those videos and see what those videos actually show. And for what it's worth, I would submit to you, they don't disprove one version as opposed to the other. They don't disprove one perspective as opposed to the other perspective. And if he comes out of that room, at that point he's getting fired on, what real choice does he have other than to stand there and take it? If the force they used was excessive, I would submit to you that the instructions allow you to decide that it was appropriate for him to fire back. And again, you have to take that into context along with his state of mind as it goes back to that extreme emotional disturbance that we talked about. He was a mess. Doesn't entirely excuse his conduct, but it certainly goes a long, long way to explaining it, doesn't it? What else did he tell us? Told us that he didn't intend to kill anybody, that he was shooting low. He got bullet holes all over that place. I think one of the officers that testified referred to it as a war zone. It looked like a war zone. Never seen anything like it. Again, everybody was firing other than Officer Holte. Before I forget, you recall anybody ever telling you that Officer Holte never had a chance to fire? Anybody hear that? By my recollection, you didn't. That's something that came out in the state's thing argument. No, he didn't fire. To speculate that he didn't fire because he never had a chance to fire is nothing more than pure speculation, and it's not supported by the evidence. And he was hit. We're not denying Mr. Pendleton was responsible for that shot. It's the only logical explanation. Mr. Pendleton was taking fire. He was firing back because from his perspective, force that was being used against him was excessive. Going to have to go through all this, make some pretty tough decisions. We submit to you that anything, Mr. Pendleton's guilty of manslaughter or to the death of Officer Holte. Why would I make that concession? Because by Mr. Pendleton's own admission, he was shooting at the officer's legs, shooting low. Well, we know from the body camera footage, that table, shots that hit Officer Holte were relatively low shots. Aiming at his head. State's made much of the plethora of gunshot defects high in the window. Again, think about sequence. We don't know if when they got there, well, they got there during that 19-second sequence of shots. I don't know what he was shooting at. Just know that he was shooting. Half a second. 30 shots, half a second apart. Bang, 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 bang. Use your common sense. It's being fired that quickly. Nobody's aiming at anything specifically. So once again, what do we have? Reckless conduct. Best we've got reckless conduct. Moving on to some of the other charges. Attempted murder. Pendleton testified he wasn't attempting to kill anybody. His perspective, he was not attempting to kill anybody. Substantial step, well, he fired his weapon. Is that enough? I would submit to you that it isn't. But suggest to you, state's case in regard to attempted murder during the first sequence of gunshots, be a little bit stronger. Attempted murder, second sequence of gunshots. There you're going to have to decide whether or not he was simply trying to save his own life by responding to what he perceived the excessive force used by the officers who were in the room at the time, that being Officer Holte, Officer Toro, Corporal Nord, Sergeant Mclean. Please get into that jury room, take a look at the camera footage. It's not as dispositive as they want it. They can suggest that it is. Simply is not as dispositive as it seems. Early on, I recall there being some testimony that you couldn't really tell which sound from which rifle. Couldn't really tell who was doing the firing at the time. It was loud, it was dusty, dirty, confusing. Maybe we should just leave it at that. He said he didn't intend to kill anybody. Have to decide whether or not his perspective on what happened is reasonable or whether it's not. Take a look at that self-defense instruction in regard to the Holte charge. It's particularly significant. Reckless endangerment. Again, Pendleton was justified in returning fire to save his own life. How can he be found responsible, recklessly endangering someone else? His own conduct was arguably justified. It doesn't work. This doesn't work. Terrorizing. Take a look at the essential elements. In closing, the state referenced the fact that they believe Sergeant Mclean, Officer Toro, others terrorized by the actions of Mr. Pendleton. It seemed to me an argument can be made that that's pure speculation on their part. Let's take a look at those essential elements. They're not even specifically identified. It's throwing stuff up against the wall and hoping that it sticks. Terrorizing and the reckless endangerment charges are something you're going to have to consider. Criminal mischief. Who was responsible for what damage? I have to sort through that because, again, you decide law enforcement used excessive force and that he was entitled to defend himself, to act in self-defense. They are just as responsible for that damage as he is. Just the way that it works. Marijuana. It is what it is. people who are inclined to use marijuana are going to have marijuana. Psychology reports on Lola Moore indicate that there was cannabis in her system. To be honest with you, I suspect that if he would have been tested, there probably would have been cannabis in his system as well. He had it. Just because he had supposedly delivered marijuana in the past, do we know whether or not it was his intention to deliver this? Again, you're being asked to speculate. They simply can't prove it, not beyond a reasonable doubt. A lot of this they can hint at, they can guess at. The issue is whether or not they can prove. We could talk about some of these things for a long, long time. Sometimes this is better than a lot. A lot of times less is better. Get into that jury room. I have to work hard. Already been working. I have to work hard to consider the evidence. And I have to work hard and go through that evidence. Do anything less or returning a verdict is going to be an abrogation of your oath. To do your best to be fair, follow the instructions. I have to remember not to get too big for your britches. Remember that the person sitting next to you has an opinion, has a perspective. It's just as important as yours. And lastly, never forget a friend. Mr. Pendleton might not be your friend. None of you have ever met him. One thing we do know is that he is one of us. He's part of this community. And to somehow pass judgment on him as it relates to these crimes based on something other than a thorough review of the evidence, be wrong. Your burden of proof is not lessened because Grand Forks police officer was killed. Grand Forks police officers, in their estimation, were terrorized and put through a terrible situation. That, ladies and gentlemen, can never be part of your discussion. Fair treatment under the law. I've probably gone on far too long. My work here is about done. I indicated it's been hard work. Yours is about to begin. All I can ask of you at this point is to do it well, best of your ability. Why? Because he's entitled to it. We're all entitled to it. And there are no do-overs in this business. Reach a verdict at some point. Whatever you decide is going to disappoint somebody. Goes with the territory. What none of us want to have happen is for you to wake up morning after the verdict comes in, week after the verdict comes in, month after the verdict comes in, start asking yourself, I'm not sure that I really did the right thing. Maybe we should have thought about this a little longer. Can't let that happen because there aren't any overs. And that's why your work is so important. It's important to do it well, best of your ability. Why? Because he's entitled to it. And there are no do-overs in this business. Reach a verdict at some point. Whatever you decide is going to disappoint somebody. Goes with the territory. What none of us want to have happen is for you to wake up morning after the verdict comes in, week after the verdict comes in, month after the verdict comes in, start asking yourself, am I not sure that I really did the right thing? Maybe we should have thought about this a little longer. Can't let that happen because there aren't any so critical to this process. I appreciate your attention this morning. As Matt indicated during her argument, folks have already been working hard. Notice juries are paying attention. That juries that didn't pay attention. Can't say that about you. Haven't disappointed me so far. No matter what your verdict is, I won't be disappointed. I'm convinced, guard, follow the instructions, did the very best that you could. Submit to you, Mr. Pendleton is not guilty of murder, compared to count 1. Not guilty of murder, compared to 2. Depending on how you view the case, may find him guilty, causing another person due to the extreme emotional disturbance aspect of this, might find him guilty of manslaughter or something less. Each one of these charges is important. Each one of them have to be decided independently. Do the best you can. Thank you.
Thank you, Mr. Modinger.